Thank you very much to that panel. I should say I'm Ed Iacobucci, Dean of the Faculty of Law, who have been collaborating with Stephen and the Monk School in putting this day's events on. But thank you very much to that panel. I think we can actually all feel reassured at the level of thoughtfulness and indeed introspection out of the media in the way these stories are covered. The C-51 has come up at a number of different points today, and the role of national security in reacting to these and other events. And our focus for the next couple of hours, we're going to have a two-part. We have two parts coming up in thinking about Canada and security and society. So our first panel will begin with the title of Someone to Watch Over Me, and so the role of CSIS power and freedom of expression. So we will be changing the name tags and start the next panel very shortly.
Good afternoon. I'd like to welcome everybody to this panel, which is entitled Someone to Watch Over Me, CSIS Power and Freedom of Speech. I know I don't have to introduce these wonderful panelists, but just quickly by name, David Schneiderman, Kent Roach, Wesley Wark, all three of whom are known to you and to, I would say, everybody in Canada these days especially. I will start with my questions, and the first question is directed to David, and I will address the panelists by their first name, if that is okay. David, could you tell us, in your view, have we learned the right lessons about freedom of speech after the Paris and Ottawa attacks?
Thank you, Sukanya. I fear that we haven't learned the right lessons. We seem to be operating under the fantasy that if we silence speech, we'll somehow be safer. Which is ironic because the first response to the attacks in Paris was to wield the pen or the paintbrush in support of freedom of expression. The first thing that happens within the first week in France is over 100 are under investigation for making or posting comments that are amounting to an apologie for terrorism. People guilty of drunken outbursts, 14-year-old who threatens to bring out the Kalashnikovs in response to being a request to show her bus ticket, are arrested, and the comedian Doug Sanders mentioned, the anti-Semitic comedian Mbala Mbala is charged with apologizing for terrorism. I understand that he's since been fined 30,000 euros, not for anti-Semitic remarks. He's been charged for that many times already, but rather for apologizing for terrorism. And I view the Canadian government's response in Bill C-51 to be of a similar type of response, and I'm thinking in particular about the proposed offense for promoting and advocating terrorism offenses in general and being reckless about the consequences that might ensue. So I want to focus in on that new proposed offense. There are other parts of Bill C-51 that seem to me to be problematic from a free speech perspective. But I'll just speak about that in particular. It seems to me in a free and democratic society, we want to encourage people to speak their own truths, and that we should be loath to ban speech that merely is offensive and which poses no real or substantial risk of harm to anyone. Yet the proposed offense would penalize speech that might have a very remote, if no connection to the threat of terrorism. There's a huge disconnect, in other words, between words and deeds. It's merely sufficient if somebody, as I mentioned, promotes terrorism offenses in general and is reckless about its consequences, which is curious because we've already got a lot of speech acts that are criminalized that are more closely connected to the commission of terrorism offenses, including conspiracies, attempts, or threats to commit, or being an accessory after the fact, or counseling the commission of terrorist offenses, including facilitating and participating in a terrorist group, which gives rise to a suspicion about what is it that the government of Canada is worried about. Well, it's worried about other types of speech acts. Stephen Blaney on CBC's Power and Politics gave us a hint about the kind of speech that the government's intending to target, and he gave the example of somebody who calls for the killing of all infidels. Simply that. Now, however loathsome that speech might be, it need not be connected at all to the possibility of any terrorism offense. One need only be, as I mentioned, reckless about the consequences. And one also wonders whether this isn't already caught by criminal code prohibitions on the promotion of hatred on the identifiable ground of religion. What's more worrisome to me, rather than the actually targeted speech, is the chilling effect of this kind of prohibition. That is that people will want to bite their tongues and steer clear of speech that runs afoul of the criminal law rather than risk offending it. And so there are all kinds of expressions of support for insurgent activities all over the world that we might want to express support of that will run afoul of, or likely to run afoul of the new terrorism law. Expressions of support, for instance, for the Free Syrian Army in Homs during the Syrian uprising, or as support for Sandinistas, right, during their battle with the Somoza government. I wonder what the prospects are for Bruce Coburn's "If I Had a Rocket Launcher" in this environment. And there are many more concerns, and actually Kent Roach and Craig Forsees have written the definitive legal opinions about the overbreadth and vagueness of the terrorism offense. But it's reasonably clear that given the fact that there's a wide swath of speech that poses no threat to us that will be caught and likely to be caught by the proposed offense, gives rise to suspicions about what's going on. And I think it's no secret to anybody in the room that what's going on is that the Conservative government is creating the winning conditions for the next federal election. Thanks.
Thank you. Wes, how well does Canada's new anti-terrorism legislation respond to the current threat of terrorism?
So as you can see, I've set myself up. And I'm going to change the discourse a bit. As I said to Kent in the washroom, I was imagining this morning what would have happened if we had somehow managed to chain Stephen Harper to a chair at the end of the room, what he would have made so far of our discussions. First of all, let me say that the partial, honest answer to the question of how well C-51 responds to the current threat environment is we just don't know. The partial, honest answer. Why? Because it'll take some time before C-51 powers are operationalized and their impacts can be evaluated. We just also don't know because we don't know, in a Canadian context, what exactly went wrong, if anything, in the circumstances around the October 2014 attacks in Quebec and in Ottawa. We're missing the connecting piece, unlike the Australians, who at least had the good grace of launching multiple official inquiries and basing new changes to their legislation on the findings, they allege, of those inquiries. We don't know and won't know because of the persistent problem in Canada of official secrecy and lack of government transparency around national security issues. We won't know because of persistent and weak accountability regimes, and we don't know because of the complexity around the understanding of the current threat of terrorism and because the threat continues to evolve. The other partial and honest answer to the question is, in my view at least, we should entertain the idea that there may be aspects of Bill C-51 that do respond, if not perfectly, at least in some respects, well to the current threat. And let's remind ourselves that Bill C-51 is omnibus terrorism legislation once again. Those of us who were around in 2001 will remember C-36, which was even more omnibus in nature, and we missed important parts of C-36 in that debate, 14 years ago now. This setup for our discussion today is understandable, but from my perspective, crazy, in the sense that there's hardly any time to get into these issues. What I did want to do to set out, and perhaps there'll be time to come back to this, is really just to try and outline the current threat as one dimension of this whole thing. And do that by counterposing two excerpts from speeches. There was, of course, the speech that Stephen Harper gave in Richmond Hill. I used to live in Richmond Hill. I can't imagine a prime minister going there when I lived there, but it's different now, I'm sure. On January 30th, 2015, on the day that C-51 was tabled in Parliament, and the excerpt is simply, he said, to fully protect Canadians from terrorism, in response to evolving threats, we must take further action. And then I want to quote from you something that I think and know is in the backs of the minds of many security and intelligence professionals in Ottawa. This is a speech delivered by a video messaging from ISIL's media spokesperson, a man named Al Adnani, which was delivered in September 2014. He doesn't deliver many such messages. This was an important one. And I just want to take a brief moment of your time to read it, because I think it is illustrative of dimensions of the current threat. It says this: "Oh, supporters in Europe, America, Australia, and Canada, you who consider yourselves from amongst its soldiers and patrons, do not let this battle pass you by wherever you may be. You must strike the soldiers, patrons, and troops, strike their police, security, and intelligence members, as well as their treacherous agents. Destroy their beds." I didn't quite get that reference, but embitter their lives for them, and this is important, busy them with themselves. If you can kill a disbelieving American or European, especially the spiteful and filthy French, or an Australian or a Canadian, I guess we're not regarded as filthy and spiteful, but we're on the list, or any other disbeliever from the disbelievers waging war, including the citizens of the countries that entered into a coalition against the Islamic State, then rely upon Allah and kill him in any manner or way, however it may be. Do not ask for anyone's advice and do not seek anyone's verdict. Kill the disbeliever, whether he is civilian or military. So that's the end of the excerpt. The nature of the current threat. We're in a post-Al-Qaeda age. And the threat is, I think, has three dimensions to it. One is that we now face jihadist terrorist groups that are attempting to acquire territory and build state-like capabilities, and perhaps even embracing, in some respects, the idea of a caliphate. Secondly, we're in a new age of cyber and social media incitement and recruitment to jihadist terrorist activities, which is also another distinguishing feature of this post-Al-Qaeda age we're in. And thirdly, there is a bridge between these two kinds of threats: the overseas threat on the part of sustained insurgencies trying to build states, and the domestic threat at home inspired through new kinds of media platforms. And that bridge is the foreign fighters' bridge. The question I think that we have to ask, if we're honest with ourselves about C-51, is are there elements of that bill, however weak and imperfect it may be, that address some dimensions of those threats? There are many, many problems, as Kent and Craig have pointed out in their unbelievably good analyses of the law, many problems with the bill. And some of those problems go well beyond the fact that it's simply omnibus legislation. But there are two elements of it that I think are worthy of our respectful attention and critique. One is the reworking of the no-fly list. And I'm happy to explain why I think this is deserving of some respect. The other is the question of having powers to go after jihadist websites and go after them in various ways. The trouble, of course, that we face is that I'm not sure we're going to manage to have the kind of debate about the details of C-51 that we really should be having. There will be, of course, committee hearings, but I think the government has signaled that they have very little appetite or intention for allowing any amendments to C-51. And we're not going to be in much of a position after it passes, presumably by the summer recess, to really follow its operationalization. So there are the bigger problems out there about transparency, secrecy, poor accountability, and lack of sustained public and to a certain extent media attention to these issues. So I'll end there.
Thank you. I was just about to jump in to say thanks, and Wesley Wark has raised many interesting points for us, as did David. And now I will ask Kent his question, which is maybe focusing in a little bit more on certain aspects of Bill C-51. Kent, Bill C-51 expands CSIS's scope and powers, and it has an impact on intelligence and evidence. Can you walk us through that a little bit and tell us, do these changes make us safer?
Sure. Thank you very, very much, and thank you all for for being here. I just want to start off as someone who I think has been described as one of C-51's most ardent critics, to actually applaud that it is legislation that we're dealing with. Some people, spoke about the Patriot Act, but the Patriot Act really did not authorize any of the most problematic stuff that the American security state did after 9/11. And so, the fact that we're having this debate, as Wesley said, there are echoes of the debate that we had 14 years ago, even to the extent of the debate about whether the exemption for protest should be lawful or not. 14 years ago, we were able to convince the government to delete the requirement of lawful. I'm not so optimistic, but I do applaud the fact that we're having a debate, and we're having, I think, a fairly civil debate. Having said that, as someone who has kind of been front and center, because I guess I didn't have anything else to do with the last month, I think it's somewhat easier for me as a person who is white and not a Muslim. And I think my colleague Mohammed Fadel spoke a little bit about the chill that at least some members of that community find. And I'm reminded of what Ronald Dworkin, the late Ronald Dworkin, said after 9/11. And I think he really distinguished himself as one of the very few public intellectuals that said that, is in all this talk about balancing security and liberty, don't forget about equality. Don't forget about whose liberty and whose speech is going to be balanced, especially when that is skewed. A second point, and the reason why I chose to address the issue of will this make it safer, is, we heard from Ms. Curl this morning about the Angus Reid poll in early February. My sense is, if you were to do a poll today, people would be even more scared. I mean, there has been an extraordinary confluence of events, and it's not just the man cave at York University. Halifax, the government may not have thought that was terrorism, but I think most Canadians recognized that had elements of terrorism. The West Edmonton Mall, up to a dozen cheerleading teams have withdrawn from a competition. And I mean, I'm not sneezing at that. I think that, we have to recognize the time that we were in, and most recently the white powder that was sent to 4 Quebec ministers. So that really has been every day since January 30th, there's been something that is pushing. And so this really does, there's a huge appetite. Canadians want to feel safer, and the issue is, will Bill C-44 make us safer? I can certainly talk about rights concerns, and Craig and I have posted all of our work so far at www.antiterrorlaw.ca. That was Craig. Craig is the 21st century partner. I'm the 20th century partner. But it was a brilliant idea, I think, to post everything. So let's start off. The Information Sharing Act. I'm not going to say much because you're going to have a panel after, but a couple of things. If everything is security, nothing is security. There is the broadest definition of Canada's security interests that I have ever seen in that act. Why the government did not use threats to the security of Canada that's in Section 2 of the CSIS Act, I frankly do not understand, and I have not heard any explanation. I worked for 4 years on the Air India Commission. We were for information sharing. Indeed, the Arar Commission was for information sharing. The Air India Commission was for mandatory information sharing with respect to CSIS's knowledge of terrorism offenses. That's not in this information sharing bill. So we're going all into, is it going to affect anti-globalization, sovereigntist, Aboriginal protests? And I don't think that those are frivolous concerns, how broadly this is written. I'm a lawyer. I just have to go by what is written. But Justice Major has, spoken out since October about the government's willful blindness towards the 5 volumes of the Air India Commission report, and that doesn't really seem to be being heard. Now, with respect to CSIS and preventive arrests, it seems to me that what unites these new powers are that they are powers of disruption. Now, we know through the CERC report that CSIS was engaging in relatively soft forms of disruption before these new powers in terms of interviewing families, friends, and so forth. But now it will be disruption that, with a warrant, can violate laws and can also violate charter rights. I think that that's a particularly radical concept, the latter, that a judge will preemptively say you can violate the charter, very different from an ordinary warrant where the judge is trying his or her best to prevent a violation of the charter. So that's a form of disruption. Wesley makes a point about the real threat that we face, and I don't discount that. But we need to know more about why CSIS feels that they have to violate not only Canadian laws, but the charter in order to engage in this disruption. Finally, you have preventive arrests and peace bonds. And Craig and I have not written about this yet, in part because we were waiting for the sort of information that Wesley was calling for. It's been 6 months since an attempt to get a peace bond on Couture-Rouleau, the Saint-Jean attacker, was turned down, and we still don't know why that was turned down. So it's very difficult, and we have been very careful not to weigh in on the significant word change that you go from will to may, you go from necessary to likely, but again, disruption at the CSIS level, disruption at preventive arrests and peace bonds are a temporary solution. It's only going to buy time in an emergency situation. And we know from the Deary case, one of the Toronto 18, who served his sentence with other convicted terrorists in the shoe at St. Anne-de-Plains, which doesn't strike me as a very good way to try to rehabilitate people. We know he was under a peace bond, and yet he was able to leave. So it seems like Canada may be backing in to a kind of control order sort of situation that may have unintended consequences. The last thing I just want to say is I accept the need that I accept the threat is changing. I accept that we need engagement. We need engagement across the spectrum. So we need engagement at the social level, working with communities, preventive. There's nothing in Bill C-51 to do that. The British legislation, which has just recently passed, does have something, puts obligations on health authorities, municipalities, even universities, and that was extremely controversial to engage in some programs. We don't know how that's going to work out, but we need that. We also, at the far end, need to have a good criminalization strategy. I think Canada was frankly ahead of the terrorist foreign fighter curve in 2013 in enacting 4 new offenses. I think that C-44 and C-51 will have the unintended effect of making it more difficult to apply those offenses when it's needed. Because you can give CSIS more powers, you can allow CSIS to be kinetic, but if someone is going to commit a crime, you still need to call a police officer. And the Air India Commission warned that the relationship between the RCMP and CSIS is still troubled, and this and Bill C-44 will, I fear, make it more troubled. So leaving aside my rights concerns, it seems to me that hastily enacted legislation with a willful disregard, and maybe I'm a little sensitive because I worked on both of these inquiries, but a willful disregard of both what Justice O'Connor and Justice Major recommended is leading to bad policy that's not going to make us safer.
Thank you very much, Kent, and thanks to everybody for your very insightful remarks. As moderator, I'm going to open up the panel now for some discussion, but I want to just share a few reflections from what I've heard. So I want to thank David for his comments on freedom of expression, the concern about the chill that would happen. I wonder even if Wesley's recitation of that speech would have at least engaged the new provision. So it's something to think about. With what Wes said as well about the evolving threat, we've asked this question very often at the Canadian Civil Liberties Association. What went wrong, if anything, with the existing laws? Why do we need new laws? And with Kent's comments, which are also I've just returned from some meetings in New York where we were discussing this, and one of the new powers that arises under Bill C-51 and taking it as well with the context of Bill C-44, if CSIS is now allowed to act abroad in a manner that pays no regard to foreign domestic laws or international law, what will this do? And one of the points that people here have made before is that not only are we in danger of violating rights, we're also in danger of being non-efficient in terms of actually getting information that's extremely valuable in Canadian and global counterterrorism. So I'd like to open up this to the panelists. And the only thing I'll say is I've been instructed to keep us to about 3 minutes each as we have a conversation. But David, would you like to comment?
Yeah, I just wanted to comment on the Wesley's noting some of the benefits of the bill. There were two, the no-fly list, and also going after jihadist websites. And it seems to me that the promotion of terrorism offenses in general that I've been describing won't get at those jihadist websites. We can't silence ISIS. That is speech occurring overseas. It doesn't seem to me that the bill will get at that stuff for the most part, right? ISIS beheading videos and calls to arms and recruitment strategies won't be caught by this. Rather, it's speech originating within Canada, and that speech often might be in the nature of the lone wolf who's posting messages on Facebook, and that turns out to be important information, I should think, for security and police agencies. So seems to undermine the very objective of the act. So I don't see how going after jihadist websites is going to succeed with this kind of drafted offense.
No, just.
I mean.
Okay. No, you go ahead.
No, I just wanted to add, because maybe I have a bit of an intermediate position here. I take David's point that a lot of this is offshore, and of course, the Americans always look at us as the security threat. When it comes to jihadist website, you could just move to the United States, and you're not going to have this sort of regulation. But having said that, I do think the warrant provision, it is based on something that was included in C-36 after 9/11. It does involve some judicial process. And so where Craig and I have come down to it is we think that you should be able to delete, while recognizing David's point about the practicalities of it, but even symbolically, you should be able to delete speech that is already criminal. So there's actually terrorist propaganda in C-51 is defined both as material that advocates or promotes terrorism offenses in general, which, like you, we have problems with, or that counsels a terrorism offense. So if someone puts out incitement, and we would say even instruction about how to commit a terrorist offense, I don't have any theoretical problems with taking that down after judicial approval. I concede your point that that might just get at a website within Canada. And there's been a few hate propaganda cases that have shown that sort of migration even to American websites that are beyond our jurisdiction.
Thanks.
Sorry.
I just add that I think it's a very valid question. I wouldn't put it in quite so restrictive a frame operationally. I would simply say that we don't know how that particular Part 3 provision of the Omnibus Bill would actually be operationalized, except we can be sure that it be operationalized by an agency that is not mentioned at all in C-51, which is the Communications Security Establishment. The provisions to allow with a federal court warrant a website hosting jihadist material of various kinds to be disrupted or taken down or material seized and so on is rooted in a notion of obviously of territorial jurisdiction, and so in that sense is focused on websites that might be targeted in some senses in Canadian cyberspace. How that would actually be operationalized is a very different issue, and it may well be much more expansive than you're imagining, David, and it may well at least provide agencies in Canada with tools to go to allied counterparts and say, you know, we found that this particular website is actually being hosted by a server in X, and we want to stop the replication of that material in Canada, and we'd be very grateful for your assistance in taking it down, which they don't have a legal imprimatur at the moment to do.
That might be fine, but the offense isn't drafted that way. You know, people who promote terrorism offenses in general might be guilty, liable to imprisonment for a term of not more than 5 years. It's a different strategy.
Yeah,
talking about this.
I want to just make an important distinction. The part of the bill that I think may have some merit has to do with the provisions not around promoting and advocating terrorism offenses, which I agree are very problematic, and I'm not sure what the net benefit of that actually would be, and I very much share, although I'm not a legal expert, Canton Roach's reservations about, you know, what it is in the current C-36 and criminal code that cannot be actualized to do that very thing. I'm talking about the very specific provisions for taking down jihadist websites with a federal court warrant. That's a separate dimension of the third part of the bill.
If I can just kind of get in between these guys, this illustrates the complexity of Bill C-51, because what I was talking about and what David was talking about was criminal code amendments that would allow a provincial court judge to issue a warrant to take down a website. What Wesley's talking about, and I think is very interesting, and I frankly hadn't really thought about it until Wesley brought it up, is a CSIS warrant with CSAC as an assisted group. So, and that's contemplated under the CSIS warrant. So here again, you have the review problem that you have CERC, and Chuck Strahl says, you know, CERC can tell you what's going on in CSIS country, but it can't tell you what's going on in CSAC country, even if CSAC is helping CERC helping CSIS execute the warrant, and this was part of the Justice Mosley decision that he just happened, because of his extracurricular reading, to twig onto and his vast experience in national security. So David and I are talking about the criminal code, which I think is actually part 3 of Bill C-51. Wesley is talking about part 4, and he may have a point that one of the illegal dirty tricks, if you want to use that phrase, may be, and of course it may not be limited to Canadian jurisdiction. And, you know, whether you need a warrant or don't need a warrant when you're doing something outside Canada is the very thing that the government is arguing in appealing Justice Mosley's decision to the Supreme Court. So the government is very shrewdly having a heads I win, tails I lose proposition, because if they lose in the Supreme Court, they got warrants in C-44 and C-51 that lets them authorize CSIS to go outside Canada. So that's the worst case scenario from CSIS's perspective. If they win in the Supreme Court. And I don't quite, it's very difficult to surmise why the Supreme Court grants leave. But if they win, then one answer is you don't even need a warrant because the Charter and Canadian law doesn't happen abroad. So we can have a debate whether CSAC and NSA, and maybe Ron Diebert can talk about this in the next panel, should work together to kind of play dirty tricks on certain websites. But the one thing I know for sure is the Canadian review environment is radically deficient. Why? Because back in 2006, Justice O'Connor said, look, whole of government information sharing, that's fine. That's a 21st century reality, but the reviewers can't be left in 20th century silos. And the government has willfully ignored Justice O'Connor's recommendations since 2006, and CERC, which is supposed to review CSIS, can't effectively talk to the CSAC commissioner, which is supposed to review CSAC. Sorry, I'm going too much into review, which is the next panel.
Well, I'm also trying to restrain myself from going too much into the next panel. But just on that last point, Kent, I wonder if we can explain it a little bit for people who might watch this later, who may be in the audience. When we talk about accountability, transparency, review standards, et cetera, we're very focused on these standards and how they apply in Canada. But what is the impact if Canada's is as deficient as you have just said, which incidentally I very much agree with? What is the impact for Canadians abroad? What sort of example are we setting when we have such low standards here? And what's happening not only with our Five Eyes partners, but with others who may be surveilling Canadians abroad?
Well, I think all democracies are struggling with this accountability gap, that governments are knocking down walls, knocking down silos, and some of the reviewers are still left in silos. But both the Australians and the Brits, although not perfect, I think are much more ahead of us. There's also been some rhetoric, and I think this is also associated with the warlike rhetoric that we heard some discussion of this morning, that now is not the time to do review because this is the time to support our security services. That, I would submit, is very, very short-sighted. And I'm not going to get into it too much because I think some people are going to address it on the next panel. But at least until very recently, many people within the security services throughout the world were saying, review actually helps us. It helps us learn from our mistakes, and it helps us deal with the kind of wacky conspiracy sort of theories. One of the things that's going to happen to CERC, just looking at the new CSIS ability to get a warrant to do illegal disruption, is people. First of all, a warrant, right? The government's saying this is judicial oversight. A warrant is a judge in a room with a government lawyer, right? There's no provisions in Bill C-51 about an amicus or a special advocate. It remains to be seen whether the federal court will require one. But the person who is being affected is not going to know about this, and those judgments are, for legitimate reasons about ongoing investigations, not going to be made public, or they're going to be heavily redacted. Well, what is going to happen to CERC? Well, if I get up tomorrow morning and my computer doesn't work, should I phone CERC? Maybe I'm being paranoid, right? But those are the sort of scenarios that we have CERC, which is 17 people, $3 million budget. You couldn't run a law faculty. You couldn't run a history department for $3 million. Sorry for taking a jab at the historians, but they were getting so much praise in the last panel. 17 people, $3 million, no inspector general, And now the degree of suspicion about what CSIS is up to is, I think even on a reasonable person standard, is going to rise. Because for whatever reason, and the government, I don't think, has yet laid its cards on its table. They may in committee when the ministers come. I certainly hope so. But they haven't told us why they need to violate the law and why they need to violate the Charter. My suspicion on the Charter is we're talking about the right of Canadian citizens to leave Canada and the right of Canadian citizens to return to Canada. And the Brits have had a very robust debate. They've come up with something that makes me uncomfortable, but they now have a temporary exclusion order, but at least they addressed it. They didn't simply say, as long as a federal court judge tells you you can violate the Charter, that's okay. Right? This is a blank Charter check that Parliament is being asked to sign off. I agree that there are legitimate reasons to debate the Section 6 right of citizens to leave Canada and to return to Canada. I also think, though, that a balanced debate about that will discuss both the cases of people in Canada that we know have gone to Syria and Iraq to fight and may come back as dangerous, maybe not dangerous people, but it also has to consider the case of Abousian Abdelrazak, who was kept out of Canada because he was on the UN 1267 list. He's been removed from the 1267 list. I mean, these are the sorts of detailed, granular discussions that we need to have. The government gives us this and gives us backgrounders that, well, I mean, one of my best friends works in advertising, so I'm not even going to say that they that they were written as advertisements for Bill C-51, because it would be an insult to my friend. When the British come out with legislation, they have detailed explanatory notes. Legislation like this in Britain would go before a joint committee on human rights, which has full-time counsel, and would, really go through this clause by clause. I hope that's what's going to happen in, however many, how many meetings? Because I mean, Sakanya's group has not been allowed to testify.
No, we haven't, and so it's a good point for me to jump in. First of all, not only are we very seriously concerned with many of the provisions in this bill that the panelists have already raised, we're also concerned with a very, in my view, undemocratic process of keeping civil society out of any sort of real meaningful participation. Fortunately, we have some of our experts included, but some of us are not included. When I say us, I'm including CCLA. And so this is something that we're looking at. But let me pose another question to you. I was going to talk about a couple of things or ask you about them. Wesley has mentioned the no-fly list. Kent has mentioned the UN 1267 list. We know that there are provisions in Bill C-51 that maybe are targeted at Section 6 of the Charter, the right to return. We also know that if you look at this within the context of Bill C-44, there are provisions in place that would enable stripping dual citizens of their Canadian citizenship in certain circumstances. We're very concerned about that. And if you consider somebody like Mr. Abdelrazak, had these provisions been in place, it's quite possible he could have been stuck in Sudan indefinitely and deprived of his Canadian citizenship. Where would he have been left? So I want to ask the panel if they could address some of these things, and maybe I could start with Wes. And one of the things I would say, Wesley, is that we were very critical about the old Passenger Protect program. We thought there was a dearth of legislative direction in terms of how people were put on that list. And there was a lot of secrecy and discretion around it. And in one of the review reports that we read, it was rather scathing of an individual who had put on it. So in your view, does Bill C-51 address some of those problems regarding how people get on this list?
Not exactly. Look, I would start by saying that all countries need some kind of no-fly list all right? And all countries that are concerned about terrorism threats have some kind of no-fly list. There are many problems and have been many problems with the Passenger Protect program, which is our name for the no-fly list, which was introduced in 2007. But I think we have to appreciate that secrecy is going to be a component of the construction of these lists, whether you like it or not. There are ways in which secrecy can, I think, be hedged in reasonable form. And one of the things that I'm going to propose to the House of Commons when I get my 10 minutes is to say that the secrecy has to be balanced against some mandated measures of transparency. So if there is a broad-based public concern that the Canadian no-fly list, as the famous Nathanson Centre letter suggests, is going to simply be like the American one, then the way to deal with those concerns is, first of all, not let that happen, but secondly, provide for an annual reporting on numbers. How many Canadian citizens are on the list? How many non-Canadian citizens are on the list? You don't list names, you don't give details, you just give people an idea of the size of the list. And I see no reasonable, I can see no reasonable objection to doing that, and it's in fact part of a current federal court case that has been launched by the Information Commissioner about providing exactly that. There are redress mechanisms for being listed, but in C-51 they are very imperfect, and I would call them Kafkaesque. Again, it seems to me very easy to improve them. The one reason, in addition to the fact that we're going to have a no-fly list, come what may, the one reason why I think that there are elements in C-51 which mark an improvement is that when it comes to security and intelligence work, I'm always afraid of workarounds. And in the Passenger Protect program, the legal language around how an individual could be put on the list referred to the expectation that such a person would pose an imminent threat to aviation security. The reality was that the people on, and we don't know the details, but the people on the Passenger Protect list did not pose an imminent threat to aviation security. That wasn't really the purpose of the list. But the legislation was badly drawn, and it forced then the interdepartmental committee that constructed the list to engage in workarounds to get around that provision because they needed a no-fly list. The definition of how a person would be put on the revision of the Passenger Protect program is, I think, an improvement. And it refers to a threat to aviation security, not necessarily an imminent threat, or the ability or reasonable grounds to believe that a person intends to use aviation to travel to join an overseas terrorist group. So at least, as Kent says, it's legislation. We can debate it. At least it's better than an imperfect system which we had to work around. And having put it out there, it is also, I would hope, susceptible to reasonable amendments to make it better.
So we would agree, obviously, that secrecy is required when you're talking about national security and counterterrorism, but we would also very much stress the need for transparency and working review and redress processes. And our concern is that those safeguards aren't there right now. I want to ask, Kent wants, yes, please go ahead.
Sorry. I agree with Wesley that legislation is a good place to start. Just two very quick points. Is actually reasonable grounds to suspect, and I think we should have a debate about that. We should also have a debate about the role of special advocates. One of the things that has not gotten a lot of attention on C-51 is that Part 5 deals with immigration law, and some special advocates have already expressed concerns that they will have less access to information under the IRPA amendment. So our special advocates, unlike the British special advocates, have expressed so far a high degree of confidence that they can do their job. That may very well change under C51. And I think that the C44 granting of human source privilege to CSIS and informers was really an attempt to try to re-win an issue that the government lost in 2004 in the Harkat case. But again, I worry about unintended consequences because the Air India Commission looked long and hard at that and decided that it would not be responsible to grant CSIS a kind of bulletproof human source privilege, which means, right, because this is fairly technical law, but what this means once Bill C-44 passes the Senate is any CSIS human source who has been promised confidentiality, which public evidence suggests is almost all of them, will have an absolute veto against being compelled either to be a Crown witness or to have any identifying information used in a warrant. So, I mean, when I testified on C-44, I sounded like a blood and guts law and order prosecutor because I genuinely think this is going to make terrorism prosecutions, including the application of those 4 new offenses, very, very difficult if CSIS is there first on the scene, which is they're supposed to be first on the scene. So, you know, again, I'm not against legislation. I think there's plenty of legislative fixes that we need, but we need to debate it in a more calm and rational environment than we are today. And the government, frankly, needs to have the humility, which the Chrétien government, to its credit, had, you know, not as much as I would have liked, but it had some humility that after Bill C-36 went out October 15th, a number of significant amendments, including sunsets on preventive arrest and investigative hearings. Not only is there no sunsets in C-51, there's not even a legislative review mechanism. So, you know, I mean, it's almost like the government right now is saying, well, you know, it has no unintended consequences. We're dealing with omnibus legislation, which actually amends more laws than even C-36. I mean, it isn't as thick, but it amends more laws. We're dealing with lots of moving parts, and the government seems to say, well, you know, this is the fix, and we don't even need to give a parliamentary committee, which hopefully would have access to secret information, which you'll talk about in the next panel. We don't even give them a mandate to look after 3 years, as the Privacy Commissioner has recently recommended, to look at whether it's working or whether it's having unintended consequences. Sorry.
No, thank you. That's we've been very concerned about these things at CCLA. So I could talk more about that, but instead, for the time that we have left, I just want to throw one question out there. Given that this conference is entitled After Paris, I'm wondering if David or Kent or Wes would like to comment on this next question. But I know, Kent, you've often talked about how speech and expression can be used to combat radicalism. And just going back to where we started with the advocating and promoting terrorism offenses that are introduced here in Bill C-51, I wonder, David, if you could start by commenting on that and the impact it might have on actually helping to counter radical speech.
Sure. And you're right to ask Kent about this because he and Craig Forsees published an op-ed just a short while ago about the promotion of terrorism and general offense and its likelihood of undermining de-radicalization efforts that are happening at the community level that are being advocated by security, intelligence, and police forces. And the fear is that as the imam seeks to engage with youth who will be gathering at the mosque, that's a likely place to find youth who might be the subjects of radicalization, that in asking them to participate in a process that engages their beliefs, their ideologies, their thoughts, their fears, their hopes, that there's a possibility that they might say things that will run afoul of this very broad, I hope I've convinced you, overbroad offense in complete disregard of charter rights of freedom of expression. And so rather than risk running afoul of the criminal code, they will abstain or withdraw and not participate. And so the perverse result of the promotion of offense, promotion of terrorism in general offense, is that it will undermine the very processes that are being advocated by knowledgeable people about de-radicalizing Muslim youth in the West. Again, I think speaks to the fact that in contrast to the C-36 debate that we had with the Liberal government, this government is preparing for an election campaign. And that, I think, helps to explain a lot of the disregard for charter rights and freedoms, for the legitimate concerns that have been raised in previous royal commissions, and the legitimate recommendations that Wesley and Kent are making. There's no indication that these will get taken up in amendments. And again, I fear that not only has anti-terrorism legislation been politicized, you'll expect that in open societies, but has been politicized to the nth degree, which seems to be consistent with the way this government operates.
And I would probably also want to point out that and I know you're not saying this, David, but our colleagues at the Canadian Muslim Lawyers Association and at NCCM, and also my colleagues at CCLA, we're all very concerned as well about the conflating of mosques and Muslims with radicalism and terrorism. So it's something for all of us to keep in mind as well. Our time is up, so I want to thank all the panelists and thank Professor Toop for the invitation today. Thank you.
Sorry for hogging it.